This week, we're going to be discussing some recent legal decisions made in Ecuador, which are potentially could have a huge impact on mining investment appetite, as well as existing operations. I am joined by my colleague Alejandro Álvarez, co-director of the mining practice at AMI. And I'm going to leave it to Alejandro to introduce our panelists, but for those of you who are familiar with Ecuadorian mining, you will certainly be familiar with these two people. But let me begin by very quickly reminding us all of what AMI does. We do enjoy our coffee chats, but what keeps the lights on, so to speak, are our consulting services. And we support the mining industry in Latin America in really 2 points of operation. First, pre-investment. Whether we're working for strategic investors, i.e. mining companies, typically majors, or we're working for lenders, or as well as alternative investors like private equity, they are interested typically in country and counterparty risk assessment. That is, what is the risk involved in the country they're investing in? What are the risks involved in the communities and provinces where they're investing? And what are the risks associated with the property or mining company, perhaps a junior, that they're looking to invest in? We can drill down to project due diligence, look at issues like social license, as well as provide some tips through this process on how to mitigate future risks. And that's important because as you put together your cost assumptions of what it will take to operate the mine in future, you need to understand what steps need to be taken to mitigate risks that are inherent to that site. Once projects are typically in the pre-licensing phase, there is another set of pressures upon mining operations as they are trying to achieve the licensing support of the government. And they need to understand the different stakeholders who may be opposing the mine, understand what is triggering their opposition and what of those fears can be alleviated with better information. If that opposition is a more intransigent nature, what do they need to do, perhaps with the government support, to lessen that risk? And then on an ongoing basis, as a mine turns to operation mode, typically mining companies go out to the marketplace through 3 budgets: public relations, government relations, and community relations. And oftentimes these 3 budgets are put together at the beginning of the year and basically unchanged. So they are executed, but the conditions on the ground may be changing, the stakeholders may be changing, the risk issues may be changing. So it's important to feed these 3 budgets and the people who are operating these budgets with up-to-date intelligence, and if need be, adjust the focus of these 3 operating budgets to better address the needs of community, better address the fears of the public, better address the concerns of government. So those are some of the things that we do in support of mining clients. Let's move forward. Now, we publish a lot of information. Each one of our coffee chats is recorded and is available on our website. We've also published a slew of articles over the years. All of these can be found in the Insights section of our website. And of particular interest over the years has been our Latin mining risk white paper, which we published a few years ago, where we break down risk into 7 categories. And it's a very useful guideline for understanding risk in the mining communities in Latin America, not only separating those 7 areas, but also seeing how they interconnect. So we offer all of this free of charge for your review. And at this stage, I think it's time on the next slide to just quickly remind ourselves of where the risks lie in mining in Latin America. Now, oftentimes in seminars like this, we're looking at national level issues, and that is the case today. And certainly they're not to be ignored. And oftentimes it's easier to build an audience around a national level discussion of national issues. But as all of you know who've invested in mining, so much of the risk is really found at the local level. And that's a lot harder to find good information on through public sources like this, or even off-the-shelf reports. Typically, you have to either yourselves or with the help of companies like AMI, pull up your sleeves and use people locally to understand what these local risks are. And there are so many, and they're so interwoven that is a whole webinar unto itself. But I just want to remind people that this is where you need to really focus your due diligence efforts, is understanding those local risks. Country level risk will only get you so far. You really have to understand what's going on locally. So with that, I will turn it over to you, Alejandro, to introduce our panel and guide us through the conversation.
Thank you, John. And thank you to our two distinguished speakers. I would like to introduce briefly María Isabel and José David, who have kindly agreed to join us to discuss the issue of the recent regulatory and judicial decisions that affect mining in Ecuador. María Isabel is the director of mining at Pérez, Bustamente and Ponce, one of the leading law firms in Ecuador. And she has been working in mining for several years, and she has kindly agreed to join us today. We thank her for her participation. We would also like to thank José David. José David is the Director of Constitutional Litigation at Pérez, Bustamante and Ponce, a colleague of María Isabel, and he has significant experience litigating constitutional actions and constitutional decisions in courts in Ecuador, which is going to be very relevant, as we will address in a moment, given the nature, legal nature of the decisions that have been coming out of the Constitutional Court in Ecuador lately. Before turning it over to our panelists, I would just like to very briefly mention what are the decisions that we are going to be reviewing today. And our panelists may have additional insights into other decisions that are relevant to mining and that have been issued lately. But we would especially like to focus on three. The first of them took place late last year on December, when the Constitutional Court revoked mining license and environmental license on the Rio Magdalena mining project, which is located at a preserved or protected forest area called Los Cedros, which is located in the northern part of Ecuador. And the decision is very interesting because the Constitutional Court argued that the Ecuadorian government had not appropriately consulted with the communities around the area, and therefore had affected their rights to clean water and a healthy environment, amongst others, which basically made the case for revoking the license that had been granted in the first place. Now, there is an interesting issue that we're going to discuss throughout the conversation, which is that in Ecuador, there is not a formally defined process, a law that regulates prior consultation. And as a result, prior consultation with communities, meaning, and as a result, there are constitutional actions and legal actions that sort of fill the void left by a legally defined process to address communities' concerns whenever there is an extractive activity projected. And this decision may be seen as a result of that, but we'll dive deeper into that in the conversation. The second decision took place in January, shortly after the first one, when the court upheld a decision on behalf of an indigenous community on the grounds of allowing that community to appropriately express their concerns over the project, and in deciding so, basically set out that all communities, native communities, indigenous communities across the country, have that right to be heard whenever there is an extractive project to be held in their lands, and the government should make reasonable adjustments to the projects and to the hearing process in order to take into account the concerns from these communities. And that is also very interesting, as we will discuss, because it applies to communities that are on a seizable portion of the Ecuadorian land and that affect pretty much all mining projects. And then finally, the third decision that we're going to be discussing is a March decision from just last month, where the court decided to grant rights to non-human animals. And this decision is not directly related to mining, but it could be, as we will discuss, because there is a significant, animal ecosystems around mining projects, and these rights that have been granted to animals may have an influence over how those projects are executed and how those projects take place. So with that being said, and with that brief context, I would like to turn it over to our panelists and begin first of all with José David to ask him about the first decision regarding the Los Cedros forest. In essence, the Constitutional Court resigned this environmental license for the Rio Magdalena project. And it was labeled as a landmark decision for the rights of indigenous groups, but it was also labeled as a significant source of regulatory instability. And the court argued that the project had violated the rights of nearby communities to the right to a prior consultation and the inherent right of the forest to protection for being a natural reserve. Do you think, José David, this is my first question to you, that this decision and others like it that you may be aware of are a result of the lack of prior consultation regulations in Ecuador? Is that a fair argument to make?
First of all, Alejandro, I would like to thank you and John for the invitation, and AMI, of course. It's a pleasure for me to be here with you this morning. So regarding your question, initially, it's important to clarify that the Constitution of Ecuador provides for different types of consultation. There is one type of consultation that is the environmental consultation. That was the issue in the Los Cedros case. And then there is the prior consultation to indigenous group that was discussed in the Cofandes Inangoy case. So when we are discussing regarding the Los Cedros decision, we are talking about the environmental consultation. What's the point or what's the essence of this consultation? So Article 398 of the Constitution provides that every governmental decision or project that could affect the environment shall be consulted to the community. In general, it's not specifically to indigenous groups. So if there's a community that could be impacted by a project or a governmental authorization, this environmental consultation should take place. What's the problem? The problem is that Article 398 provides that the law is a statute issued by the National Assembly regulates the consultation, how it should take place, the criteria by which the activity shall be analyzed, etc. In my opinion, after the Constitution was enacted in 2008, the National Assembly did issue regulation regarding the environmental consultation. So in essence, the problem in the Los Cedros case was not caused because of lack of prior consultation regulations, because there were statutes issued by the National Assembly and regulations issued by the Ministry of Environment that indeed regulated the environmental consultation. Actually, the projects, what the law in the regulation said is that prior to advanced exploration, you should perform the environmental consultation. The problem is that in 2021, in December, the Constitutional Court issued the judgment in the Los Cedros case that considered that the law did not adequately regulate the environmental consultation. And the court created, and that's my opinion, the court created new standards regarding the environmental consultation that did not exist previously under Ecuadorian law. So it was problematic that in the Los Cedros case, although the environmental permit for the initial exploration was made in accordance with the applicable law and regulations, the Constitutional Court rescinded it because it considered that it did not comply with the standards that were created in December in 2021. So the problem, I insist, is not a result of lack of prior consultation, but instead the violation of the principle of non-retroactivity of the law. I sincerely believe that the court, throughout this decision, created a scenario of legal uncertainty. So that with regard to the environmental consultation. However, Article 57 of the Constitution does recognize the right to a prior consultation for indigenous group in accordance to the International Labor Organization Convention that provides for this specific right for indigenous groups. And in that case, and I'm referring to the Cofán de Sinangoy case, the problem was lack of regulation. Because in 2011, when the Constitutional Court assessed the constitutionality of the mining law, it indicated that the National Assembly had to enact an organic statute that regulates prior consultation. The National Assembly failed to do so. So in 2019, the Constitutional Court issued a new decision declaring that the National Assembly failed to comply with that obligation and gave the National Assembly 1 year to enact a statute that regulates prior consultation. So that was in 2019. We are now in 2022, and the organic statute regarding prior consultation has not been enacted by the National Assembly. So I believe that in the Cofanes case, the Constitutional Court took advantage of this situation to develop on its own standards regarding the right to prior consultation.
Okay, thank you, José David. And building on that, do you think it is accurate to read that as a result of this decision over Los Cedros forest, both miners and the government now have to undertake quote unquote precautionary measures, such as carrying out detailed scientific studies to ensure that a project's activity does not harm fragile ecosystems, endangered species, and overall the communities, the local communities' rights, and therefore sort of increase their costs of compliance with regulation?
I believe that the Constitution already provided that before a project could be performed, specific environmental studies should be developed before the mining activities can take place. So basically, the Constitutional Court's decision did not invent the precautionary principle or any other principle in regarding to the protection of the environment. What happened, as I explained before, is that according to the law that was in effect before the Los Cedros case, if you were undertaking initial exploration, you didn't have to perform an environmental impact statement. You just filed for a registration, an environmental registration, because the activities that you perform in initial exploration basically are not harmful for the environment. So, and that was what the Ministry of the Environment considered. So because the activities were so minimal and had so minimal impact to the environment, it was necessary just to file for a registration. But since if the investor or the miner would continue to the advanced exploration because the activities have more impact to the environment, pose a higher threat to the environment, then you will have to do an environmental impact statement, and the environmental consultation. Now the Constitutional Court says no. I mean, there's no way that you can carry out initial exploration without an environmental impact statement and without the environmental consultation. So that, of course, creates an additional requirement that was not enforced before. And additionally, regarding this principle that you mentioned, Alejandro, the precautionary principle is now like at the center of the stage in constitutional litigation regarding mining cases, because of the Los Cedros case, or after the Los Cedros case, the environmental activists are filing new constitutional actions, claiming that in specific ecosystems or environments, because they are so complex, so unique, so diverse, there are no conclusive scientific studies that could indicate that mining activities will not irreparably harm the environment. So since they argue that there is no legal certainty, they are claiming that the government should limit or restrict the activities under the principle that since we don't have scientific evidence, the best way to protect the environment is just to restrict the activities on their face. So of course, this is the center of the constitutional cases, and we can discuss regarding the cases that have been filed afterwards if you would like, Alejandro, of course.
Thank you, José David. I will touch back on that in a moment. I would like to turn it over to María Isabel for a moment and discuss the next decision that I mentioned during my presentation, which is essentially that in the Constitutional Court set this new legal precedent in guaranteeing the right to consent for indigenous people over extractive projects on their lands, and did so in this deciding a lawsuit by the ICOFAN community. You will let me know, María Isabel, if I'm pronouncing it correctly. According to the ruling, if an indigenous community refuses a project, the government can still move forward in some quote unquote exceptional cases. However, the court states that under no circumstances can a project be carried out that generates, and I'm reading here from the court's decision, excessive sacrifices to the collective rights of communities and nature. And it's interesting because the ruling applies to all 14 of the country's recognized indigenous groups, whose lands include a little over 70% of the Ecuadorian Amazon, which is rich in both oil and minerals. María Isabel, I would like to ask you, what standard is the Constitutional Court implementing in relation to prior consultation after the ICOFAN case?
Thank you, Alejandro, and thank you, John, for this invitation. It's really interesting to see how these landmark cases are changing some perspectives about the mining industry locally. Well, in this particular case, the mining concessions involved that were located nearby the COFAN community in the Amazon of Ecuador, those concessions were left out without effect, and the court stated that the right to be consulted was violated. As you may be hearing, this right to be consulted, and as David was mentioning, it's a very different, it's a collective right that should be respected and that should be guaranteed and granted by the state to the communities before starting any project involving extractive industry and non-renewable resources. So what is the court saying in this case? The court is saying that prior consultation should not be considered as a mere formality, and it must be conducted first by the authority in charge of carrying out the projects. And the curious thing is that they are stating that that prior consultation should be performed even before starting the calls or the auctions for the awarding process of mining rights in any type of mining regime. And the court is also stating that prior consultation should be performed even before prospecting, which is very difficult for mining companies, because according to mining law, prospection is free and you're able to do it even without any permits. So this particular standard, it's a very confusing to the mining industry right now. And also the court is stating that prior consultation is not limited to those projects located within the lands of indigenous communities or indigenous people. The court rather, it's saying that this standard, it's also applicable to those projects which, while not located there, might have a direct environmental or cultural impact on the indigenous communities' rights. And that's because they are located within the area of influence, and not just because they are located in the exact territory where the indigenous communities live in, but it could also be said that if a community such as the Cofán community considers that a project located nearby or in a location further to that community could affect their rights, they have the right to participate in the previous consultation. Particularly, the Constitutional Court is setting out additional standard for the prior consultation. And for the first one is the duty to compromise in the plan or project subject to the consultation. This means flexibility to change or to cancel the project based on the results of the consultation. There's also an increased duty to take reasoned decisions based on the results of the consultation. And of course, there has to be noted that there should be an impossibility, or the court considers that the state could have an impossibility to require disproportionate sacrifices from indigenous communities, which are not proportionate in a democratic society and not proportionate with the collective rights in play.
Thank you, Maria Isabel. And in your opinion, what will change for miners and mining investors after this decision? And how do you think both miners and investors should react to ensure that they comply with the court's ruling?
Well, one of the most relevant things that was raised, or one of the most relevant issues that was raised in this case, was that a constitutional judge was taking out the effect of a mining concession due to another connection with a violation of a collective right. However, it is well noted, and the Constitutional is granting the exclusive power to the state, in this case, the Ministry of Natural Resources and Energy, to grant and to take out the effects of mining concessions. So this, of course, is raising an alert in the mining investors that even if they are under a regulatory basis granted by the mining authority, they have to be aware of the possibility that a local court could take the effect of a mining title that was duly granted. So I think that is changing, and as we are going to discuss further, we're going to have a lot of constitutional actions that could potentially raise this issue before local courts. And the judgment issued by the Constitutional Court has also big implications, of course, for extractive industries, not only mining, but oil industry as well, because it is establishing a very rigorous standard for prior consultation, requiring that this consultation be conducted even before the very early stages of mining activities, such as prospecting activities. And this situation could slow down the awarding process of titles and mining concessions. As you may be aware, the government of Ecuador is now announcing a potential opening of the mining cadastre. They have been working for almost 3 years with the World Bank and the Inter-American Development Bank to set up a more efficient process of the mining cadastre. So for sure, having this very strict and rigorous standard could slow down this potential opening of the mining cadastre, because it is stated that the government must first check whether those areas that are supposed to be granted are subjected to the prior consultation process. And although the Constitutional Court admits that effectively the prior consultation is not binding and that the state has a way out in case that it disagrees with the opinions of the communities, the judgment is establishing a more complex standard relating to the implementation of prior consultation. So they are no longer requiring just a simple consultation, as I mentioned at the beginning, but they are requesting a true negotiation with the potential affected communities. This for sure could eventually result in the cancellation of some plans or some projects.
Thank you, Maria Isabel. José David, I would like to get back to you with a question about a recent decision that is not currently displayed on screen, but it is, I think, relevant to our conversation, which is a decision by the court where it declares the water law, which had been enforced since 2014, unconstitutional because it fails to guarantee the water as a public and communal good. And it is perhaps a result of concerns expressed by all communities across the country, but especially indigenous groups, that the law allowed for a state intrusion into their rights to water and land use. So I would like to ask you, José David, is it fair to argue that this decision that we are discussing in the screen regarding animal rights and the court's decision to determine animals as having inherent rights that have to be protected, can that decision be deemed as a consequence of the Constitutional Court's recognition of rights to nature, including the rights that have been given to water and other natural ecosystems?
Yes, Alejandro. So just for purposes of a better understanding of the audience, in 2008, when the Constitution of Ecuador was enacted, the Constituent Assembly recognized nature as a holder of specific rights, or nature as a right holder with specific rights. So after that recognition, there was an important discussion in law schools, in the society, between activists and lawyers, regarding if nature was the only right holder, or if the specific parts of nature were entitled to rights as well. So there have been several decisions in which the Constitutional Court has established that, for example, a river, in Los Cedros' case, a forest, and in this case, a monkey, is an individual right holder, or a part of nature entitled to rights. So what are the consequences of this? And it's very important to analyze this decision because according to the people or that argue that nature is the only right holder according to the Constitution, Article 71 of the Constitution only provides a specific set of rights for nature. Like, for example, the right to exist, to flourish, to regenerate its vital cycles, and to naturally evolve. Those are the rights that the Constitution or the text of the Constitution specifically provides for nature. But why would the Constitutional Court say that a specific part of nature is entitled to rights? The analysis is, or the point is, that the court is indicating that when it sets out, when it identifies that there's a specific part of nature with specific characteristics, the point of recognizing as a right holder is to protect it in a better way. So, for example, a forest is entitled to different rights because it is a forest. So in Los Cedros' case, since it was a diverse forest, it had endangered species. Part of those rights of the Los Cedros forest was the right of those species to not be extinct. A different set of rights would apply to a monkey, like, for example, in the Estrellita case. The Estrellita case involved an habeas corpus filed on behalf of that monkey. So the rights of the monkey would be to not be illegally detained, and in this case, to not be subject to living with a woman during 18 years, as happened in this case. So the court is trying to take the analysis in order to protect in a better or a most robust way the environment. In setting out that recognizing nature not as an object of economic exploitation, but or just as a source to satisfy material needs of human beings, but as a part of the economy with its own rights. The court is trying to point out that there are specific parts of the environment that have intrinsic value, and recognizing these parts of nature as right holders will help to adequately protect this specific right holder. So this will change the analysis for us, like in the mining industry. How can this impact us? Well, if we're trying to make or to carry out a project in a specific forest, we will have to understand how diverse this forest is. If the activities could affect a river, we should take studies to understand what are the relationships between this specific river and other parts of nature, because this could be a specific analysis in order to determine what rights this forest or this river could have and how mining activities could impact those specific rights. In the Los Cedros case, the Constitutional Court said that since the Los Cedros was such a specific ecosystem and was so unique and so diverse, mining activities were incompatible with this right holder in particular. The court said that this analysis should be taken on a case-by-case basis. So returning to the point I was saying at the beginning, the Constitutional Court, while aiming to protect the nature and the environment, is creating legal uncertainty because these new factors regarding new actors or new right holders should be now analyzed when trying to carry out a mining project.
Thank you, Jose David. And it's interesting that almost simultaneously to these decisions, there was a discovery of two new species of so-called glass frogs. And they were discovered near active mining areas in the Andes. And I don't want to go out of my element here, but I believe these discoveries are very relevant to the scientific community because these types of frogs are unique in that they have completely see-through bellies that reveal their hearts, their liver, their digestive systems. And so it may be that in applying these principles that you have described to protect these new species that carry both intrinsic rights and substantial scientific value, the court will affect mining projects. I would like to turn it over real quick to María Isabel for a moment and go back to the law that we were discussing a moment ago, the water law, which was declared unconstitutional by the court. One of the things that the court mentioned in its decision was that reparations that had been ordered by lower courts prior to the Constitutional Court taking on the case, reparations must be paid by both private companies and by the governments. Can you please provide some insights into what these reparations are and how they will be applied, and what can private companies, miners, and investors, as well as the Ecuadorian government, expect in light of this decision?
Yes, thank you, Alejandro. This is also a landmark decision. We've been getting a lot of those decisions due to this change of thought in the Constitutional Court. The court has just changed. So we're expecting to see whether this trend of thought is going to change or if they're going to keep this. So it's very interesting to discuss this decision as well. What happened in this case, in the case about the water law and the regulations to the water law, is that the court declared that the law was unconstitutional by the form, and it was due to a lack of a pre-legislative consultation. The pre-legislative consultation, it's also a collective right that's granted by our Ecuadorian Constitution, and it's something that must be performed, a very important process that must be performed by the legislative in and within the process of a lawmaking. According to the Ecuadorian Constitution, any process for the enactment of a bill of law, of a law, that may affect the territory where indigenous communities are located, or that may affect any collective rights belonging to the indigenous communities, should be submitted to a pre-legislative consultation process. This is a mandatory process, and according to the plaintiffs in that case, in the Constitutional Court case, this law did not comply with that specific process due to a lack of integrality of the text that was presented to the people, a lack of good faith in the consultation, and they also stated that the pre-legislative consultation was not appropriate according to cultural standards. So in relation to the substance of this case, the alleged constitutional case was not warranting the progressive exercise of the right to water that's recognized under Articles 57 of our Constitution. In addition, they were also discussing that easements in ancestral land are unconstitutional, and they were alleging that the law was also promoting privatization of the water as a natural resource. Well, all regulations also must pass under an independent project for the pre-legislative consultation. So the court was approaching, on one side, the enactment process of the law, and also the issuing process of the regulations to the water law. So at the end, both of them were declared constitutional because there were no pre-legislative consultation process. The right to prior consultations, according to the international, to the OAT convention, goes beyond simple hearings. So in this case, that's what the court was stating, that a genuine dialogue should be carried out, and not just simple hearings, calling of actions to the using the media, because they were saying that it is not appropriate to call some indigenous groups to the media, and that's why the consultation did not comply with these cultural standards. In this case, in any way, the consultation was executed. The National Assembly performed a pre-legislative consultation. However, according to the court, this process did not comply with the requested standards. They say that the National Assembly unilaterally decided which topics will affect indigenous communities' rights, and they say that it was not the indigenous group of people the one deciding which are the topics that may affect their rights. So the court determined that the assembly should be flexible enough prior to the enactment of any law to modify the original bill of law after the results of the pre-legislative consultation.
Maria Isabel, thank you. And I would, in just a moment, I'm going to turn over to the audience to see if there are any questions. But before doing so, I would just like to ask you very briefly, these reparations that the court ordered as a result of declaring the water law unconstitutional, could you give us very briefly an overview of how this will affect specifically mining operations?
Well, what the court stated, they stated a measure that is called, called to an action when you will have a gap, a major gap derived from the unconstitutionality of a law. So in relation to the use of water, declaring this unconstitutionality of the law for sure left a major gap on the regulations, on the law applicable to the permits and authorization for the use of water. So what the court stated is that the former provisions applicable to water permits and water resources were remaining to force until the National Assembly is able to process a new law in compliance with these pre-legislative consultation standards. The court is providing the National Assembly and the executive branch for the regulations to the law, a term of 12 months for them to start working on a new regulations complying with all of these new standards. So the court is now saying that before all the processes of in relation to water permits and the use of water that were filed to the environmental authority before this judgment will remain into force and will be submitted and subjected under the law that was into force before the judgment of the Constitutional Court.
Thank you, Maria Isabel. And I would like to turn it over to the audience at this point. I believe we have one question from John to José David. John, please go ahead.
Thanks. I have two questions. One is related to prior consultation. José David, you mentioned that the court has sort of taken upon itself to define this because the legislative branch basically hadn't done their job to define it. And, you know, this is a problem we see across the region. All these countries signed up for the ILO 169 years ago without really understanding the consequences of that. Oftentimes, mining companies are more than happy to do a prior consultation, but where things fall down and where they fail is because the rules aren't set very clearly. So in this effort by the court, did they define, for instance, the geographical perimeter that has to be included of communities that must be consulted? Do all prior consultations lead to a referendum vote, and who gets to vote on that? And are those vote results binding positively or negatively? In other words, if the community votes in favor of the project, can they reverse their position later on? Were these sorts of ground rules set in place to make it clear? Because the biggest conundrum this has caused over the last few years is precisely the lack of definition that's kept miners back.
Yes, John, thank you for your question. Yes, the court touched upon these matters. So regarding the place, because this is a very important aspect. Both the ILO 169 and in Article 57 of the Constitution provides that prior consultation must be performed when projects or activities will take place on indigenous territories. However, the Constitutional Court said that the government should carry out the prior consultation even when the projects are not located within indigenous territory. The standard is that the prior consultation must be made even when there is indirect impact on indigenous groups that may affect them socially or in their culture. So, as you said, these are no clear rules. I mean, if the court would have confined, as the text of the Constitution does, to prior consultation within the territories, we would have a clear picture. However, the Constitutional Court said territory is not decisive. You have to go and analyze a little bit further if there are indirect impacts, or if the groups can be affected socially or culturally, even if the projects are not carried out in their territory, prior consultation must be made. So this opens the question, so when exactly do we have to carry out prior consultation? We will find out later when prior consultations procedures take place. Regarding who should be consulted, yes, the Constitutional Court said that it is not enough to consult or confer with the indigenous authorities. The whole communities should be consulted. So the court didn't define a specific referendum mechanism, but it said that the whole community should be consulted. We expect that this matter should be cleared or developed more clearly when the National Assembly enacts the statute, the organic statute regarding prior consultation. And regarding the effects of the prior consultation, the Constitution is very clear. If the indigenous community does not approve, if they vote negative to not allow a project, the government can continue with the project. The Constitution provides that very clearly. However, the Constitutional Court said that although the government may provide, even if the community or the indigenous community opposes the project, in no case the project can continue if the damages caused to indigenous groups are disproportionate or are not proportional. So once again, that creates legal uncertainty. because that standard, when does a project does not or is not proportional to indigenous rights, that's not clearly stated in the law. That will be decided by the courts later. So I believe, that's my personal opinion, that the court, while providing this standard, was trying to keep the power to itself to define later, at a later stage, when the cases go to court, if the authorization or the decision of the government to carry out with the project, to continue with the project, affects or duly burdens the indigenous community.
Great, thank you. I have another question related sort of broadly to the third court decision around the rights of natural, of both animals and nature in general. And there's a question from John Williams in this regard. He asks, who has standing to bring legal action on behalf of nature or parts of nature? And I would add to that, you know, as you provided your sort of diagnosis of this latest court decision, you know, my mind sort of wandered and thought, gosh, you could oppose almost any project if you broadly interpret this. So along the lines of John Williams's question, my question to you is, what are you advising mining companies? Are you sort of saying we have to wait to see how this is adjudicated in a case? There's going to be limits to this, but we still don't know what. How are you advising people?
So, John, regarding this case, it's important to point out two things. So, as I mentioned first, this is not the first case in which the court recognized a part of nature as a right holder or a specific right bearer. So, this case, in essence, does not change that because this is not new. But of course, this case is relevant because it's the first time that an animal, in this case, a monkey, was recognized as an entity that has rights. So that from the first point. And the second point, and I believe that it doesn't change the analysis because the constitutional, or I mean, it does, but not definitely, because at the end of the judgment, the Constitutional Court provided or gave 6 months to the ombudsman to draft a bill that regulates the rights of nature. And that bill should be discussed in the National Assembly, and a law that protects the rights of nature should be enacted according to the Constitutional Court judgment in 2 years. So in 2 years, we will have the definite regulation or the definitive statute that will regulate this. At that point, mining companies will have more certainty how this will apply. In the meantime, as I mentioned before, mining companies should take studies or should pay close attention to the environment or the ecosystem in which the project will be carried out. Are there specific animals that live in the region? So, for example, John, what is happening right now after the Los Cedros case? So after the Los Cedros case, there was a constitutional complaint filed in Imbabura, in Yurimawa, in the Yurimawa concession, and I participated directly in that case. So in that case, there were 2 species of frogs that were recently discovered. So the environmental activists, they say, hey, those frogs were not mentioned in the environmental impact statement, nor there were actions provided in the environmental management plan to protect these frogs. So if mining activities continue in Yurimawa, these animals will become extinct. So that was the essence of the discussion, and they argued the precautionary principle. Since we don't have scientific evidence of the impacts of mining regarding this species, the government should restrict the activities, and the Yurimawa concession must stop all its activities. So what we are advising clients when this happened, where there are unique species or unique ecosystems, is that the environmental impact studies should do their best efforts to identify the characteristics of the environment, to carry out the scientific studies and develop the best management plan possible. And if in the meantime, while you're operating the concession, you find out this species, well, you should inform the authority and immediately try to undertake or implement measures in order to protect those species. So if you go to court, you can say that these species are adequately protected.
Thank you, José David. And I would like to ask María Isabel specifically about John Williams' question. María Isabel, what is your take on who has the legal right to bring an action on behalf of nature or parts of nature?
Thank you, Alejandro. Well, according to our Constitution, any person is entitled, specifically Article 71, any person is entitled to or has the standing to pursue a claim in relation to the nature's rights. However, there should be taken into account that there's a difference between my standing to claim and what are the benefits or the indemnification that I will pursue through that claim. In any case, talking about the nature's rights, any type of reparation or indemnification that a particular person is pursuing on behalf of the nature has to go directly to the benefit of the nature's rights. The right to preserve the nature circle, the right to preserve the nature as a holder of rights. And as David was mentioning, any person could sue even for the potential violation or the affectation of the rights of an animal, such as the case that we were mentioning. So it is also very interesting to mention that this trend of thought in relation to the nature's rights is taking a little bit more force in the region. We have just saw that in Chile, the Constitutional Commission has just approved the nature as a holder of rights in Chile as well. Prior to that, Ecuador was the only jurisdiction including this trend in relation to the nature as a holder of rights. So there's an interesting discussion along several cases that had been treated in Ecuador and other legislations related to environmental damages and environmental consultations related damages. But in the case of a nature's right and an animal that is part of a nature, any person has the legal standing. But of course, there's a specific action to do it, and there's a specific reparation that should be granted by the local courts as well.
Thank you, María Isabel. We are nearing the end of our call. I think we do not have time for any more questions if we want to stay on time. But I do appreciate both of you, María Isabel and José David, that you joined and that you were so detailed with your explanations and with your responses. This is a very interesting subject, and I think that one of the things that is clear from our discussion is that there will probably continue to be decisions from the Constitutional Court and from courts all over the country that will affect natural resource extraction, both mining and oil and so on. So this will continue to be of interest, and we will very much continue to monitor what comes out of Ecuador. But for the time being, I would like to thank everyone who joined the call, all of our participants, and I would like to thank John for his questions, and once again, José David and María Isabel for joining and for your very informative insights. We look forward to having you again in another panel very soon, and to everyone else on the call, please remember that we conduct these mining coffee chats the first Tuesday of every month. So please stay tuned for our next coffee chat on the month of May, where we will address other topics that are of interest to mining. So with that said, again, thank you all for joining. Thank you, María Isabel. Thank you, José David. And we will be in touch.